Good afternoon, everyone. And once again, our apologies for running a few minutes late, as you all know, for the benefit of members of the public. The members of this committee who also serve as government ministers had their weekly committee meetings this morning, which would have run somewhat late. So it's not anything that was purposefully done, but rather it was unavoidably so. So we apologize. We are 123. And I want to welcome officials from the Ministry of Finance, Ministry of Health, Chemistry, Food and Drugs Division, the National Insurance Property Development Company, and the Office of Procurement Regulation. The batting order, to use a cricketing analogy, which we propose to adopt today, is that we will take Ministry of Health and Chemistry and Food and Drug Division in a compendious fashion. We propose to do the OPR once there's enough time for that, because I think, or we will start the OPR today at least. Hopefully we will get to NIPDEC at some point in time today, time permitting, bearing in mind that all the senators and the members of parliament who are committee members have volunteered to stay, but we have to be mindful that we have public servants who are here providing their assistance, and we want to be mindful of their transport arrangements. And some of them live in fairly far-flung areas of the country, so we want to be mindful of their need to get home at a decent and respectable hour as well. So that is the batting order as we propose to start. I want to welcome from the Ministry of Health, Mr. Asif Ali, the Permanent Secretary, Dr. Janine St. Bernard, the Chief Medical Officer Acting, Mrs. Mala Kaulesa-Tagley, the Legal Advisor. From Chemistry, Food and Drugs, we want to welcome again, and consistent in his attendance, Mr. Hasmath Ali and Mrs. Anisa Doodnath-Siboo, the Principal Pharmacist. From the Office of the Procurement Regulator, Ms. Beverly Khan, the Chairman and the Procurement Regulator, consistently attending before us, and we are very grateful for that. We have Ms. Clessie-Ann Ellis, the Senior Auditor, and Ms. Melissa Ramkwar Singh, Head of the Policy Department. From NIPDEC, we have Mr. Vyas Ramphali, the General Manager, Mr. Alvin Solomon, Medical Supplies Coordinator, and Mr. Jabari Kozia, Head of Finance and Accounting. So now that we've done that, I think that from the previous public airings of this committee, the public is well aware of the jurisdictional ambit of this committee, and as such, I don't propose, for the sake of the public record, to read that further into the public record. I simply want to get on with the task at hand. We've started at 1, and I want to get on with it. The purpose of this meeting is to continue the inquiry into the state's acquisition of pharmaceuticals as it relates to the current process applicable to its importation and approval. The role of this committee is to assist the stakeholders in achieving the efficient delivery of services while ensuring that expenditure is embarked upon in accordance with parliamentary approval, to determine the challenges being faced and possible solution to these challenges, and make recommendations for improvement of public administration. The meeting is being held in public and is being broadcast live on Parliament's Channel 11 and Radio 105.5 FM on the Parliament and on the Parliament's YouTube channel, PAL-View. Viewers and listeners can send their comments related to today's topic via email pal101@ttparliament.org. Whilst I have said the names of the members of the persons who are in attendance, can I just ask everyone, for the sake of the members of the public looking on, if you can introduce yourselves, please. Ministry of Health.
Sure. Thank you. Good afternoon again, Chair members. Asif Ali, Permanent Secretary, Ministry of Health.
Good afternoon, Chair and members. Dr. Janine St. Bernard, Acting Chief Medical Officer, Ministry of Health.
Good afternoon, everyone. Mala Kaulesa-Tagley, Legal Advisor, Ministry of Health.
Good afternoon, Chair, members. Mohammed-Ali, Acting Chief Chemist and Director of Chemistry, Food and Drugs.
Good afternoon, Chair and everyone. Anissa Doodnath-Siboo, Principal Pharmacist, Ministry of Health.
Good afternoon, everyone. Beverly Khan, Chairman and Procurement Regulator, Office of Procurement Regulation.
Good afternoon, everyone. Ms. Clessie-Ann Ellis, Senior Auditor at the Office of Procurement Regulation.
Good afternoon, everyone. Melissa Ramkumar Singh, Head Policy Development, Office of Procurement Regulation.
Good afternoon, everyone. V.S. Ramphali, General Manager, NIPDEC.
Good afternoon, everyone. Alvin Solomon, Medical Supplies Coordinator, NIPDEC.
Good afternoon, everyone. Jabari Kozia, Head Finance and Accounting, NIPDEC.
Okay, so I think that completes the introductions. Can I just ask, so by way of introduction, the ministry, invite the ministry. I think on the last occasion we had the opening statement, right? So what I want to do is I wish to start with chemistry, food and drugs. And I want to start on somewhat of a topical issue. It has to do with the approval of pharmaceuticals being imported. I want to direct these questions to Mr. Ali. Am I directing it to the appropriate person? And to also, oh yes, there are two Ali, Mr. Hasmat Ali and Mr. Asif Ali. So I suppose I can direct the question and the answers can come interchangeably from both of you or come collectively from both of you, whichever is more helpful. All right. I just want to throw out some general propositions, first of all. And then we will get into the questioning. So am I correct that pharmaceutical management and supply chain management is, would you all agree with me that that's a matter of critical national importance? Would you also agree with me that part of supply chain management is the prevention of an over-reliance on a concentrated supply chain pool, both geographically and both supplier-wise? And I think one of the things that we learned coming out of COVID, insofar as other industries are concerned, is that where there is a supply chain management choke point, as it's referred to, very grave potential national risks are involved if your supply chain management is concentrated in a few or one entity. Am I correct with that? And that is even more critically important insofar as the management of the supply chain involving pharmaceuticals. Am I not correct? And in that regard, would it also be correct to say that it is part of the policy framework and the policy imperative of the Ministry of Health, being the policy-setting body, to ensure that supply chain management of pharmaceuticals does not concentrate itself in a few or a singular supplier so as to result in a potential national choke point of the supply chain. Am I correct?
Chair, that's a discussion point, and I will tell you why. When we look at the registration of pharmaceuticals, and that's what the forte of the Chemistry, Food and Drugs Division is, there is an opportunity for anybody in Trinidad and Tobago to apply for registration of a pharmaceutical product. Therefore, it does not preclude or it does not exclusively allow large importers to only import or register pharmaceuticals.
I'm not on that point, Mr. Ali. We're getting there.
Yeah.
So as a result of what you've just told me, am I not correct that once a pharmaceutical is registered,
That's correct.
no one owns the exclusive right to bring it into
That's
Trinidad?
correct,
So the stages are very different.
yeah.
Registration merely allows the importation,
Correct.
but the importation is not exclusive to the person who's registered it,
That's correct.
right? In your experience, has customs prevented entities from importing pharmaceuticals which have been registered by other persons?
No, Chair. Customs has not prevented, as far as we know, anybody from importing registered pharmaceuticals. What has prevented persons from importing registered pharmaceuticals is the contractual arrangement that some of these importers have with manufacturers.
Now, hold on. Right, so contractual arrangements.
Yeah.
Let's examine that in some greater scrutiny and isolation. All right. Okay. First of all, customs is a revenue collecting agency, is it not?
Yes, Chair.
Customs is not a commercial policeman.
No, Chair.
Customs is not a court.
No.
Customs doesn't determine who has the contractual right to import a product or not import a product.
That's right, Chair.
So how does customs know of the contractual right of any entity to import or not import?
Chair, I don't think customs would stop a shipment from coming in once the product is registered, right? So I would not say that customs would stop any legitimate shipment coming through the borders once the persons would have done so legitimately.
All right, let's focus on the meaning of the word legitimately.
Product has been registered. They have if it's a controlled drug, there's a controlled drug permit issued by the Chemistry, Food and Drug Division, and that's what legitimacy means.
Right, so it doesn't mean to say that if one company A in Trinidad, we're not going to identify anybody, has a contractual arrangement with a manufacturer whom we shall call B in any country, that company C is precluded from importing that drug into Trinidad and Tobago.
That's correct. Company C can import the drug into Trinidad and Tobago.
So
as far as
why
we are
did
aware.
why did you refer to contractual arrangements as being
I was just,
a preclusionary consideration?
So, Chair, I was just explaining the fact that sometimes with manufacturers, if they do register a drug in Trinidad through a local agent, they would not allow that drug to be sold to another party, meaning that other parties are not allowed to purchase the drug from them for export or import into Trinidad and Tobago.
All right.
I must explain that point.
No, hold on. Let's examine this in some greater detail. Because you're telling me that customs hasn't stopped it.
No.
As a practicing lawyer, and Minister Maraj also as a practicing lawyer with some experience in this field, the anecdotal evidence which both of us have access to and are familiar with is something completely different.
Right.
I'm afraid that we are not being told, given the complete picture here, if I may put it as mildly as that and as neutrally as that.
Yeah.
The anecdotal evidence which both of us are familiar with is that shipments are routinely stopped in customs because importers are told they are not the agents.
Okay. Chair, I can
So
answer.
the question I'm going to ask you now is, does the Chemistry, Food and Drugs Division keep a database as to who the agents are?
We do have a list of applicants who would have registered the drugs. in
Right,
Trinidad
so
and
the
Tobago.
list as far as you are concerned merely is the entity which registers the pharmaceutical.
That's correct, Chair.
But registration does not preclude widespread importation outside of the entity which registers.
That's correct, Chair.
Right. What I want to know is why importers of legitimate drugs, registered pharmaceuticals, are being stopped at the ports for importing pharmaceuticals into Trinidad which have been registered? That's my question, and whether the Chemistry, Food and Drugs is consulted by customs on any basis as to who has registered these pharmaceuticals. I see Mrs. Siboo shaking her head, and I'm going to take that as the invocation of the doctrine of nodding approval, which Minister Maharaj knows all too well. I would imagine that, yes, Chemistry, Food and Drugs is consulted on a regular basis by customs to find out who has registered these pharmaceuticals.
Chemistry, Food and Drugs would have been consulted with respect to the drug being registered and basically the registration status of the drug.
All right. When you say registration status, what
whether
do you
it's
mean?
registered or not registered, Chair.
And
if
is
it's
there
registered, it would the drug, basically the drug should be allowed to be imported.
Right. One step at a time, Mr. Ali. When an inquiry comes from customs as to the registration of, let's say, pharmaceutical X, is a part of the inquiry who it is registered, which entity has registered it?
Yes, that is part of the inquiry, Chair.
Why would that be the business of customs, if I might add?
Just to create the linkage between the local importer and the manufacturer.
All right.
For
okay.
registration.
Fair enough. But wouldn't you agree with me that in those circumstances, the only way the customs can prevent the importation is if there's reasonable cause to believe that those pharmaceuticals are counterfeit? If it's registered.
If it's registered, and there are legal documents to show that the product is registered, that comes with the shipment. So if those documents are presented to customs and it's cross-referenced.
Hang on a second here. I think I am afraid we seem to be at cross purposes here somewhat. Let's take it step by step, because this is very important, and I'll get to the reason why it has become more critically important shortly. Registration, first of all.
Sure.
So it's registered.
Yes, Chair.
Although on the last occasion we got evidence that there was no official publication of it anywhere. Right. Subsequent to our last meeting, we got an assurance that it would be published. I'm told that it is almost ready for publication. Can you confirm that?
Yes, Chair.
Right. So it's registered. Wouldn't the extent of the inquiry of customs merely to be, is this drug registered?
Yes, Chair.
Right. So what other documents need to come with this shipment except a bill of lading, the certificate of origin, the declaration of value, the C82, the C85, 82, the C75 forms, and the bill of lading? What other document, once the pharmaceutical is registered, what other document is expected to come from the manufacturer?
So, Chair, those would be the documents that the manufacturer would have sent, and that information is then cross-referenced with our local, with the Chemistry, Food and Drugs Division to validate that the product is registered for importation into Trinidad.
Right. So what I want to say to you is this. Sometimes the manufacturer sells to a distributor, and if the distributor issues the bill of lading and issues the invoice, the manufacturer name doesn't appear on it.
Correct, Chair, and that's where the Chemistry, Food and Drugs Division would then have to validate the manufacturer of the drug, because...
How do you do that?
Well, there are two ways, Chair. One, we could do a physical inspection, or two, we could ask for documentation from the importer to validate that the product is manufactured by the registered manufacturing site.
And if the importer buys from a third-party distributor, how is the importer able to satisfy that?
They get the information from the third-party distributor, Chair. But we've had instances where importers would have gone back to the distributors where they would have purchased the drug to validate that the drug is registered.
Is there a clear, unambiguous, published policy document which members of the public and the importing public can have recourse to and satisfy itself that there's a clear procedure for that?
Unfortunately, Chair, there is none at this time.
So this is done on an ad hoc basis?
No, Chair, it's not done on an ad hoc basis. The Customs and Excise Division, and as well as the customs brokers, are very clear with regards to the mandate of the Commission
Well,
for Food and Drug.
how have they become clear? What document has guided them?
Chair, this has been a practice that has been ongoing for a very long time, so I would have to assume that this practice has become the norm
You see,
with the arrangement with
Mr. Ali,
Commission
why
Food
I
and Drug.
ask you that, right, is that governance is an exercise in certainty and predictability and reliability. What you're telling me here describes a very haphazard approach to the importation of registered pharmaceuticals. That's what you're describing to me. A very haphazard approach. And to put it in Trinidad language, it seems to be almost a Vicky-Vi approach. Wouldn't you agree with me?
Well, Chair, over the years, again, mechanisms have been put in place. The Ministry of Trade has launched the single electronic window platform on which all importers of major pharmaceutical shipments would have their documents uploaded and reviewed by the various border control agencies and approved before the shipments are allowed into Trinidad and Tobago.
And yet we have a problem which persists, that people who import registered pharmaceuticals are routinely stopped at the ports of entry because they are not registered agents. Wouldn't you agree with me with that?
That is not a plausible reason for holding the shipment.
I understand that, and I accept that entirely. But what I want to know is, if it is not a plausible reason, why does it continue to happen on such a consistent and persistent basis? I think my brother, Mr. Baraj.
Mr. Ali, I think the question was, does it happen? And I don't think you directly answered that question. The chairman asked the question, are they routinely stopped if they are not the registered not importers, the distributors in Trinidad? And the question was, are they routinely stopped at the port of entry? And what is your answer to that question?
I would say that would not be the reason to stop the shipment, Chair.
We're not asking what's the reason, you know.
Well, no, Chair.
Are they stopped? Do you have knowledge?
I do not have knowledge. I do not have knowledge of that fact that they are stopped because it's imported by a non-agent.
So you have not received inquiries from time to time from customs making inquiries about that?
Not about the agent rule, Chair. It would have been for different reasons with regards to not having the proper documentation when shipments come in or the validation of the registration status of the drug.
Well, what does that mean, validation of the
registration? Again, if the drug is registered in Trinidad and Tobago,
yes.
But I must also point out the fact that...
Hold on. Before you go on to pointing out, what does valid registration status mean?
The drug has been registered in Trinidad and Tobago.
Right. And what must the importer produce with regard to that to the customs?
Proof of registration, that the drug has been registered, but not to customs, and so that's where I was going with the explanation.
Mm-hmm.
The body responsible for ensuring the registration of a drug and who has the authority under the Act to verify that would be the Food and Drug Inspectorate. Customs does not have that authority.
I understand that.
Right?
So where does the importer get that document from?
The importer can either get the document if it's the registered agent. If not, the importer will get that document from the list of gazetted drugs and provide the gazette number to show that the drug has been registered.
So you can get it from a public document?
From a public document.
No, but hang on a second. Mr. Maraj, can I just jump in here? On the last occasion, you told me that there was no single list that was available.
Chair.
And the Gazette, hold on, and the Gazette I asked you specifically whether or not an importer had to scroll through all the years of Gazette to get a compendious list, and you told me yes.
Yes.
And it was only subsequent to that, there was a promise made, the very same evening this committee was adjourned, that that list would be published.
Yes.
So I guess what my learned friend is asking you is, how does the importer access this list?
Yes.
When there's no one compendious list that exists thus far.
So, Chair, as we explained at the last sitting, that list is being prepared and will be provided to Customs. It is also being prepared in tandem with the database that's going to be published at the end of the month to the general public. So both of that is being prepared. What I'm speaking about is what has been happening previously with regards to the importation. If somebody wants to import, then they would have to go through the list, the Gazette, to get that registration information to provide to show that the drug is registered.
But Mr. Ali, you don't find that that is a huge disadvantage to any importer with regards to competition and so on?
I would totally agree with...
Why would such a thing be allowed to continue to frustrate a possible entrepreneur who wants to bring in pharmaceuticals and so on? It seems like an almost inbuilt disadvantage there. When your division, at now the urging of the chairman, is now going to produce that document in 2026? Why?
I want you to bear in mind the factual, contextual background that this list was promised in January of 2023. We're now in March of February, I'm jumping ahead of myself, 2026. And despite the repeated promises, 3 years after, that list just has not appeared. It's like the Sesame Street character, Snuffleupagus. Everybody's talking about it and nobody's seeing it.
But Mr. Chair, I'm flabbergasted. A young entrepreneur sees a drug being sold, for example, $10, and knows he can bring it in for $5, but he does not have this necessary information in Trinidad and Tobago to be able to pursue that line of business because that is not available from you all?
Honorable Member, apart from not having the list, there's always the opportunity, which is on the website, for persons to reach out to the Chemistry, Food and Drugs Division. And in fact, that's something that we would have asked all importers or would-be importers to do, to verify that, one, drugs are registered, that the label has been approved for use in Trinidad and Tobago. So there are opportunities for persons to reach out to the CFDD for that information.
So how is a would-be importer going to avail himself or herself of that information? How does he know that that is where he has to go? Do you have a public, that is why I asked just now, is it publicly available? And you told me that it had to scroll through the Gazette. Right. Now you saying there's another route?
There is another route where they can reach out to the Chemistry, Food and Drug Division
to
verify.
You have to go into the division and ask them?
No, there's an email address that's available on the website that you can send an email in.
Seriously, this government, you want to send an email and expect a response in this bureaucracy?
Or they could call in as well, Chair. Or they could come in. So there are opportunities.
You expect a call to receive and to get a response in this bureaucracy, Mr. Ali? You seriously proposing that to this public listening to you?
But those are the opportunities that we have available, Chair. Honorable Member, at this time.
Okay.
3 years after it was promised. January of 2023. 12 months, January of 2024. 12 months, January of 2025. 12 months, January of 2026. Nothing doing. Don't you find that counterintuitive to the core principles of good governance?
Chair, one of the things we have to remember, when that proposal was made in 2023, the database was now being built. There were issues, issues with it.
Hang on a second. The Food and Drugs Act, right, is number 8 of 1960.
Yes, Chair.
So in 2023, after 63 years of the existence of the jurisdiction in the Food and Drugs Act, number 8 of 1960, 63 years later, you are now compiling a list?
We do have a list, Chair, but the database that would be available to the public is not...
That is not the point we're on, Mr. Ali. We are on the point of public accessibility. We're on the point where the public can guide itself with a reasonable degree of certainty, clarity, and transparency. That's the point Mr. Maraj and I are on. And you're telling us that 63 years after the passage of this act, after the Chemistry, Food and Drugs Division was given jurisdiction, it still had not compiled a list. And even though it promised it in 2023, 3 years have gone by and still has not done it. Look, the answer to that is no.
I'm curious to hear the response, Mr. Chair. Why was that done?
So let me explain, Honorable Member. The list we do have a list of registered drugs. The list that is going to be made public to the public, which is the database, that is what has been working on for the last 3 years. We have a list comprising of more than 22,000 drugs, and therefore the information that needs to be provided for the public needs to be information that they would understand, right? We have to be very careful as well when we publish information that there are certain bits of information that is confidential, that cannot be given out to the public, and therefore the information is being looked at and revised so that the public could understand that information clearly and make a conscious decision, and I guess that is what that database is for, so that the public can make a conscious decision.
I'm interested in the confidentiality aspect you just talked about. Yeah. What could possibly be confidential about pharmaceuticals that would be in the possession of the ministry?
The application documents that are submitted, there are clauses in there that are considered confidential information.
What proprietary information is in the application form? And we'll get to that. That's a good segue into where I want to go. But I'll allow Mr. Maraj will ask his question, and then I will come back.
Thank you, Mr. Chair. Just by way of example, one example of a confidentiality bit of information that cannot be published. Just by way of information. So I can wrap my mind around what you're trying to get at.
Chair, this time I can't suggest, but I could probably send it at a later time.
Yes, Minister Batiste would like to ask a question.
I was listening, and to me, I'm awfully confused. 22,000 names of drugs that are registered. What about that cannot be shared with the public? I'm saying again, 22,000 names of drugs that are registered. What beyond that? And why can that not be shared immediately with John public?
All right. So member, with regards to those 22,000 names, right? It's not just the name of the drug that is being shared with the public on the database. It's the name of the drug, the active ingredient, the therapeutic uses as well, right? So when the public gets that information, they can make a conscious decision with regards to the drug when they purchase it. The name itself, sometimes we have instances where you have supplemental changes being done by the manufacturer with regards to drugs that are registered. And if we do put out the list as is, without having considered some of those supplemental changes, the information is going to be wrong. So again, to get back to the point why it has not been published, we have a verification process where we want to make sure that the information that is being published to the public is in fact correct and up to date, and therefore the information once put out there would be adequate for the public to make a conscious decision in purchasing and use.
Minister Prasad?
Yeah, there's one. technical question in terms of ICT. You have a database.
Yes.
You have endless fields in the database, right? You will have the name of the drugs,
Yeah.
right? You will see the sort of ingredients, the active ingredients in the drugs, etc., right?
Yeah.
So if you have this large database, there's nothing wrong in pulling out the fields. People who are going to import the drugs, no entrepreneur is going to all of a sudden decide to import a drug he doesn't know about.
Yeah.
So he must know, he would know about it. And therefore, I don't understand why if you put out the name of the drugs, all right, and also the active ingredients, just 2 fields, which you can pull from your database very, very easily. You can do it tonight, actually. Why that cannot be done?
Yes, Minister Alexander?
Just was that decision a legal decision, or was it an in-house decision to not let that information come out?
Historically, a list was never provided to the public.
We're
right?
painfully aware of that.
Yeah, so it's something that the ministry is currently working on in terms of providing to the general public. So I would not want to say, I would allow PS to answer with regards to the reasons why.
All right, so I want to get on to the, before we get on to Permanent Secretary Ali, you see this? I want to be very neutral in the language I use, right? This cloak of confidentiality which you've invoked to adorn yourself of an exemption for disclosing has me somewhat troubled. I'll tell you why. The requirements for registration are plainly set out in legislation. You agree with me?
Yes, Chair.
It's the Food and Drugs Regulations Division 2. Am I not correct?
Correct, Chair.
In an appendix at the back of the schedule of the Food and Drugs Act.
Yes, Chair.
And it's Regulation 3 of Division 2. Okay?
Yes, Chair.
So let's go through it and let's see where the confidentiality argument stands up to reason. Because you have several lawyers here. Confidentiality might be an irrelevant consideration in public law principles, but we'll get to that. So the first requirement is that it must contain, and this is for the benefit of the members of the public looking on, right? So if an importer wants to import a new drug, he has to comply with the requirements of Section 3 of Regulation 3. Am I correct?
Correct, Chair.
Regulation 3, and this is a very, very important, I want you to give careful consideration before you answer me, is contained in the form of subsidiary legislation. It's not a policy statement, which is different. You agree with me?
Yes, Chair.
So this is a legislative framework approved by the Parliament of Trinidad and Tobago, not a policy.
Yes, Chair.
Right. So Regulation 3 says, subject to paragraph 4, the forms must a description of the new drug, including the manufacturer thereof, and a declaration of the proper name and the name under which it is proposed to be sold. Correct so far?
Correct, Chair.
A statement of all the ingredients, contraindications, and all of that. The tests applied to control the potency, purity, and safety of the new drug. A draft of every label proposed to be used in connection with the drug. Samples. And such samples of the components of the new drug as the director may require and shall include one or more, so that if the samples submitted are not enough, if in the discretion of the director more samples are required, the director, which is you,
yes, Chair.
Right? You can require more samples.
Yes, Chair.
Then it goes on to say, it says, a certificate from the Food and Drugs Administration and of the Department of Health, Education, and Welfare of the United States of America, certifying that the new drug is approved for use in the U.S. and giving the conditions of which it is sold in the U.S. Similarly, from the United Kingdom, Australia, okay? And then the certificate in English language and all of that. So right away we see that there's a somewhat antiquated approach to this because it leaves out major drug manufacturing centers such as Germany, Canada, India, and several other manufacturers. Hence my reference early on to the supply chain choke point, the creation of a supply chain choke point. Okay?
Yes, sir.
Now this is subsidiary legislation, right? And I'm going to ask you a very pointed question here, and I want a straightforward answer, Mr. Ali. Were additions to these requirements made in let me get the date correct, because I have around 2017?
No, Chair.
Who was the Director of Chemistry, Food and Drugs in 2017?
Mr. Faris Khan.
Mr. Faris Khan. Were requirements made for additional documents? P.S. Ali, I know you know the answer to this. Were, and I'm going to direct this answer to you, and I want this answer in a very straightforward manner. I want the answer to this question in a very straightforward manner. Did Mr. Faris Khan, the former director of the Chemistry, Food and Drugs Division, require additional documentation in 2017 by the secretary, the then secretary of the Drug Advisory Committee? Was that done? P.S. Ali?
Chair,
the answer to that is yes or no, eh?
Well, Chair, the answer is I don't know because I wasn't there in 2017. And, but I do know there were some changes to the requirements previously that were not grounded in the legislation, and Mr. Ali would speak to that in terms of we have sought to remove those.
Right. So, Mr. Ali, are you aware that in 2017, the Secretary of the Drug Advisory Committee, and I'm going to hold up a document in my hand, right, so that you know I'm not bluffing. Did the Secretary to the Drug Advisory Committee in 2017 make changes to Section 3, which I just read out to you, without publishing those requirements?
Yes, Chair.
And those changes which were made had no basis in legislation?
No, Chair.
Right, so let's get to the bottom of this now. A minor functionary who is the secretary to the Drug Advisory Committee, let's lay out the scenario. In 2017, says, I am going to change legislation by way of a requirement that additional documents be provided. How was this communicated to persons?
Chair, what we saw is that the application form was amended to include certain documents in that application form that was sent out to members of the public.
Who gave the instructions to amend the application form?
Chair, when I did searches, when I came into office, I could not have found minutes from the Drug Advisory Committee, neither directives from the Director of Chemistry, Food and Drugs at that time, nor from the Ministry of Health.
So, one morning, magically, as if to say, someone woke up in 2017, marched into the ministry, and gave instructions that the forms were to be amended. Where is that documented anywhere?
I have not been able to find any documentation, Chair.
And the minister's involvement at the time, because you would agree with me, and I'm holding this up, under the Food and Drugs Act, the minister has a very wide supervisory jurisdiction over this.
That's correct, Chair.
So where could this decision possibly have come from?
And Chair, unfortunately, I have not been able to get that answer. as a result of which, Chair, in September, I would have asked for the form to be reverted to the form prior to 2017.
So when did you first realize? So this happened in 2017. When did you become Director of Food and Chemistry?
I started acting Director of Chemistry, Food and Drugs at the end of May 2025.
May 2025. What was your position before?
I would have been the Registrar of Pesticides and Toxic Chemicals under the Pesticides and Toxic Chemicals.
P.S. Ali, when did you become Permanent Secretary in Health?
2018, Chair.
2018. So 1 year after this illegal act was performed. Let's not mince words. This was illegal. It was unlawful. Ultra-virus the act. The lawyers here will shake their heads. Okay? You became PS 1 year after this. When you first became aware of this.
This actually would have been in 2025, Chair, also. I was not aware
So
that
this rogue public servant who enacted an ultra-virus requirement for something as important as the importation of new drugs into Trinidad was allowed to continue unchecked and unabated for 7 whole years, 8 whole years, without anybody in the ministry realizing that these forms introduced requirements that had no basis in law? Is that what you're telling this committee and the members of the public? 8 years. A patent, plain, pellucid, and palpable illegality was allowed to prevail in the importation of pharmaceuticals before anyone took any measure to arrest this action? Is that what you're telling me, P.S. Ali? You are now there 8 years, huh? Yeah. You came there in 2018.
Correct, Chair.
This happened in 2017. Surely the then minister must have known about this. You cannot tell me a public servant took it on his own to do this without the involvement of other persons in the ministry. Ministries just don't function that way. P.S. Ali, can I get a straightforward answer?
Sure. Chair, the issue of the Drug Advisory Committee and the drug registration process is one that has been of concern to the ministry.
P.S. Ali, I really want to be very respectful to you. I'm not interested in those generic answers. I want a specific answer to the question I've asked you. And I say this with the greatest of deference and respect that I can muster up at this stage, because it is alarming and disconcerting that a public servant with unbridled contumely and disregard for the statutory requirements could simply have done this on his own. You and I both know, and every member who has experience here in governance, public servants just simply don't do that. This must have happened at the direction of someone, and we'll get to the details afterwards, but I just want a straightforward answer.
Chair, as Mr. Ali would have said, when we found out about this and we tried to ascertain exactly where the instruction came from, who was aware of it, there's no documentation, there's nothing except what was issued by the officer for those changes.
And who was the officer?
The secretary at the time was Dr. Derek Patron.
Sure. All right. So Derek Patron issued instructions to the government printry to introduce additional requirements on a form, or acting entirely on his own. That's the story you're trying to tell me here. That's a narrative you're conveying to me. Dr. Derek Patron
Gentlemen, you need to drink some water or something? I think what the chair is trying to ask, who could have issued that instructions to Dr. Patron? Easy.
And we are not, I don't have a clue, Honorable Member. And like I said, in 25, when I came in, because of what my background is, I started doing an investigation into the requirements for drug registration.
All right. What prompted that investigation? Surely you must have received complaints.
When I came into office, there were some complaints coming in that the application was a bit onerous. Some documents, persons, especially smaller importers, were saying that there were some documents that they could not have gotten for the registration of drugs. I started looking at the requirements for registration against the legislation, and I realized that there were documents that were being asked for that were not listed within the example that was given in the legislation. I also interviewed a number of persons, the past secretary of the Drug Advisory Committee.
Who that same Dr. Patron?
No. The secretary who would have retired in 2017.
Who is that?
One Mr. Dexter Sherland.
Right.
As well as Mr. Khan, to find out if it is that a directive was given. I looked at the minutes from the Drug Advisory.
Which Khan you're referring to?
Mr. Fars Khan.
Mr. Fars Khan?
Right.
Mr. Fars Khan confirmed to you that it was Dr. Patron who...
He confirmed that he never gave that directive for any changes.
So hang on a minute. Let's get this scenario correct, right? And that's why I used the word haphazard before. And perhaps haphazard being an English word doesn't adequately convey the utter sense of confusion that was going on there. Perhaps vaikivai is the correct word to use. Yeah. So the Director of Chemistry, Food and Drug, who has the statutory responsibility for approving drugs and setting the requirements for the approval of drugs, allows his authority to be subjugated and subverted by the Secretary of the Drug Advisory Committee, who performs a largely administrative role and not a technical role. That's what you're telling me?
Yes, Chair.
And Fars Khan, who's a former senior officer, did nothing to arrest this situation for 8 years?
I did not.
I'm going to absolve P.S. Ali from this for now, because P.S. Ali is removed a little bit, administratively and perhaps geographically and jurisdictionally, right? But the supervisory jurisdiction fell to Fars Khan. Mr. Fars Khan, I want to be respectful to him. So when Mr. Khan got this form from Dr. Patron, is there any evidence that he would have said, hold on, where did you get this jurisdiction from? Who authorized you to do this?
So I did not get any official documents, neither in the interview that Mr. Khan indicated that he revoked the requirements that were submitted by Dr. Patron.
All right. So let's get this going now. Ministries, yes.
I presume Dr. Patron is no longer there?
Dr. Patron is still at the Chemistry, Food and Drugs Division.
In what
He's an inspector.
He's an inspector?
Yes.
At that time, he was the secretary?
Secretary of the Drug Advisory Committee.
And when did he demit office as secretary?
The board expired, the DAC expired in November of last year. And with the appointment of the new DAC, a provision was made to hand the secretariat over to the Chemistry, Food and Drugs Division for us now to determine a proper secretariat structure for the Drug Advisory Committee.
And in the course of your extensive inquiries, which you said you conducted, did you have a chance to speak to Dr. Patron?
I did speak to Dr. Patron, and the response that was given to me was speak to the DAC or the former director, which I did, and I did not get any information from neither. And there were no minutes indicating that there were any changes or recommended changes by the DAC to the requirements, which of course, as Chair indicated, should have been approved by the Honourable Minister So I did not receive any ministerial documents to show that any approvals were done.
And did Dr. Patron admitted to having been the author or sending the document to be published?
He did not admit to him making any changes, but being secretary for that period of time, I saw a definite change in the documentation from post-2017 to pre-2017.
Was he asked the question, were you the one who sent it to be published in the regulation or wheresoever?
It was not changed in the regulation, honourable member.
Oh, it was just changed in the internal documentation.
Internal documentation.
Right,
the form that was sent out to the importers.
Right. So did he admit to being the one making that alteration?
He did not admit that he made the alteration, except, like I said, when I asked him, he told me to ask the DAC or the, yeah.
Okay, thank you.
So when you spoke to Mr. Faz Khan, and he told you it was Dr. Patron who did it, did you go back to Dr. Patron and tell him, Dr. Patron, Mr. Khan is saying you told him this. You did this.
I didn't go back to Dr. Patron.
But why? Wouldn't that be the normal line of inquiry?
I think based on the inquiry, I went forward with the inquiry beyond what Mr. Khan said to see if there was a ministerial approval or ministry approval.
So let me ask you this then. Ministries don't function like that, right?
Right.
When that form went to the government printry, that form is printed by the government printry, is it not?
No, Chair.
So where is it printed?
It is printed at Chemistry, Food and Drugs.
All right. So who does the template?
So there's a template that the secretary has that he prints the form and gives it out to the...
Right. So where is the computer data that was inputted into computer to reflect those additional documents? Who inputted that data?
Dr. Patron.
And you confirm that by a check on the computer?
Because he would have created the new versions.
So,
I did not check the computer, but he created the versions.
So hold on. So when you went to him and you asked him pointedly, did you do this and why you did it? And he plainly dodged giving you an answer when he told you go check with somebody else. Didn't you confront him and say, but Dr. Patron, hang on a second, the evidence is you did it?
I also sent out an email to both Dr. Patron and the drug registration officers indicating, of course, that the form we would have looked at did not comply with what was done previously, and therefore that the form would have to be changed to reflect the previous requirements.
No one in a ministry for 8 years, from 2017 up until you went there in May of 2025, no one went to the minister and said, Minister, this is ultra vires the act. Or the permanent secretary. No one, even let's move up the ranks, the AO4, the administrative officer 4, 5, permanent secretary, whatever, supervisors, whatever. Everyone simply allowed Dr. Patron to be a runaway horse. Nobody imposed a check and balance on Dr. Patron. Is that what you're telling us today? And there's another dimension to this, which we'll get to now. So here you have a rogue officer simply imposing his peculiar will on an entire regime, and no one raises a hue and cry. This escapes complete administrative attention for 8 years. The silence is deafening, Mr. Ali. I suppose it's deafening because I'm correct. Mr. Maharaj?
It's a bit startling, this information that is now coming. During that 8 years, any importer or commercial person involved in drugs and so on Is there a file where people are making complaints that this is too onerous? Why have you all imposed that? There's any thread at all of people complaining?
I have none, and I really can't say about the last 8 years because I was not there.
No, I just wonder if there was
a file. I don't know, but I know when I started, persons were complaining that some of the information being requested is very onerous on them.
So presumably when you started the complaining,
I suspect that they were complaining previously, but I mean, I heard their cries and I decided to look into it.
And okay, thank you.
If I could crave your indulgence shortly. My recollection is that the private pharmaceutical board did make some complaint about this. All right, so can I just read this for you, Mr. Ali? I'm reading from the submission of the Private Pharmacy Retail Business Association at page 28. And this is what they say. They say the Chemistry, Food and Drug Division Department provides a significant function in the safety for the population of Trinidad and Tobago. As pharmacists, health professionals, and distributors, we recognize the need for checks and balances. However, within the last few years, stakeholders from whether inside or outside the Ministry of Health have realized the department needs reformation. Within the last 10 years, reports of many small distributors have seen the level of difficulty in getting items, whether they are vitamins or OTC over the counter, from countries which have stringent regulatory authorities get approval from our local CFDD. A review of this and they go on, right? But there is, I will find it here, but there is some anecdotal evidence emanating from the private pharmacy of extreme difficulty in complying with those requirements, okay? So, Mr. Ali, I want to ask you something now. The ultra-virus requirements which were introduced into the forms, and we've accepted they were ultra-virus, illegal. For the benefit of the public looking on, illegal and unlawful requirements were imposed on importers, which persisted for 8 years. Don't you find it startling that those documents, these additional documents, could have been sourced by some importers and not sourced by others?
Yes, Chair.
Would it be reasonable to say that this additional document requirement, which was plainly ultra-virus, was introduced with the intention of creating an impossible requirement to compliant, impossible compliant framework? Would you agree with me? All right, let me put it in plain terms. The new document requirement that was designed to favor certain people and rule out certain importers. I've been very frank with it here.
It would have made it very onerous for some importers to get a document, or those documents.
In effect, allowing the pharmaceutical industry to be controlled by a select few.
Yes, sir.
And let me ask you further. 2017, you were Food and Drugs. PSLE, you know, because it's part of the regulatory framework. When did the acquisition of smaller pharmaceutical distributors commence in this local market? The smaller firms being gobbled up by the larger firms. When did it commence? The creation, the genesis of the creation of a monopolistic environment. When did it start? Am I not correct? It started around 2017 with the acquisition of smaller firms? Minister Maharaj probably has a lot more information than I do. I see. Wouldn't you agree with me that in the last 10 years, there has been a consolidation of pharmaceutical importers into mega firms?
Yes, Chair, there has been a consolidation within the last 10 years.
And this consolidation has gone unchecked.
Yes, Chair.
And this illegal, ultra-virus, and unlawful requirement which you say, you are pointing the fingers at Dr. Patron. Natural justice and procedural fairness will now dictate that we write Dr. Patron and Mr. Ali, inform them of the allegations being made against them today, and give them opportunity to come here to give evidence.
Sure. Yes, Chair.
So, depending on what they say, then that might add some more ingredients to this callaloo, which is emerging here today. Right? So, my very helpful secretary has found the part for the private pharmacy. I want to thank her for it. Page 9 of the private pharmacy submission. The disadvantages of procurement and distribution are many. These include unnecessary restrictions by CFDD to register drugs both old and new. For example, restrictions are understandable for new molecules, but to restrict a vitamin, a registered vitamin, for example, Centrum, because it comes in a different size, is unnecessary. What do you say to that, Mr. Ali?
I hear the statement being made, but I don't think it's with regards to the different size. A lot of time when products are registered, if they are not, they are also registered by manufacturing sites. If the manufacturing site is different from what is registered, it will require a new registration. Chair.
All right. So let's go on. This is the allegation that this private pharmacy makes, and I'm going to give you an opportunity to respond to it.
Sure.
In addition, the CFDD handling of new drug registrations appear to be selectively allowing registration for certain distributors to be fast-tracked and approved expeditiously, also creating a monopoly in drugs approved. The process is further complicated and made difficult with CFDD introducing many policy changes with the requirements needed for drug registration, all of which are not CFDD Act or law. Then they go on to make a conclusion. This is a concerted effort to block registrations and reduce competitiveness in local procurements and distribution of pharmaceuticals nationwide. Right? So that gets me to this point. And now it will become clear why I was asking you the questions early on, the role of customs determining who registers. Am I not correct that of 1,000 pharmaceuticals registered in this country, one company has been allowed to register almost 800 or 900 of them? I'm not going to name the company.
Yes, Chair.
So whilst that company, that one single company, has been allowed to register almost 90% of the registered pharmaceuticals, the small importers, have found it impossible to do so because of the plainly illegal and unlawful requirements introduced by a rogue public servant. Don't shake your head. I want an answer for the record.
Yes, Chair.
Senator John Bates has a question.
This clearly. Dr. Derek Patron, yes? He is the one we're saying authorized the changes to the form and we're speaking about. Are you saying he authorized these changes in his, I'm saying he's a doctor, his capacity as a doctor or in his capacity as the technical secretary to the Drug Advisory Committee?
Secretary to the Drug Advisory Committee.
And in his capacity as the technical secretary to the Drug Advisory Committee, is it that he would have been executing a decision of the whole committee?
In reviewing the minutes of the meetings, I did not see any reference being made to any guidance from the Drug Advisory Committee to advise the minister on such changes.
Right, so we're saying, I guess that's why we're using the word rogue.
Yes.
And just to inquire, did you go back to any of the other members of the committee? I know you said you spoke to Mr. Faz Khan, but the committee has a whole other list of individuals. Did you inquire?
I did not go out to the members of the committee. I kept it in-house and spoke to the director, or the past director, seeing that he would have been Dr. Patron's supervisor at the time.
And so no reference at all to this change?
I did not find any references to the change.
Thank you.
Right, so let's get on with it a little more, shall we?
Chair.
Ms. Alexander, you go ahead.
Just want to confirm something. So a form was introduced, a new form was introduced, and then you are saying now the form was removed.
No, the form remained the same. There were new elements that were added to the form.
Right, those elements were removed?
Were removed from the form.
Without any conversation, any legitimate or any legal terms being added or reviews or anything like that, it just moved, just like it came in?
No. When I realized that there were additions to the form, I consulted with our permanent secretary and let them know that there were amendments that were made to the form based on, again, on my historic review of the application form that was used prior to 2017. Subsequent to that, because we had to engage the public, we went ahead and removed those requirements. And of course, because they were not legitimate in the first place, have the current form formatted so that not the current, but the previous form formatted so that members could have availed themselves of what the previous requirements were for the registration of pharmaceuticals.
So, Chairman, so what the Chairman is saying, and would you agree that all the transactions that took place between 2017 to date, until you changed that form, was in fact illegal?
Yes, if there were requirements on the form that were not previously asked for for registration, it then becomes a matter of concern.
I want to ask you about someone else. Do you recall someone by the name of Imtiaz-Ali?
Yes, I do, Chair.
What was his role? Let's go to the history of it. What was his role in the ministry at the time?
He is a Food and Drug Inspector, Chair.
A Food and Drug Inspector. Now, under the Food and Drug Inspector, under the Food and Drugs Act, a Food and Drug Inspector has a very limited jurisdiction. You agree with me?
Yes, Chair.
And I could go through it if you want for members, benefit of members of the public, but the jurisdiction is clearly set out and adumbrated in the Act. Okay?
Yes,
a Food and Drug Inspector performs no role with the Drug Advisory Committee. You agree with me?
No, Chair. Food and Drug Inspector 2 would be appointed as Secretary to the Drug Advisory Committee.
Okay. Was Mr. Imtiaz-Ali a secretary at any point in time on the Drug Advisory Committee?
He was not Secretary of the Drug Advisory. He was never appointed as Secretary to the Drug Advisory Committee.
Was he a member?
He was never a member of the Drug Advisory Committee.
All right. Was Mr. Imtiaz Ali in charge of a committee overseeing drug registrations?
He would have been asked by the previous director, as well as myself, to assist in the screening of applications being submitted for registration.
All right. Have you seen a report prepared in which screening applications performed by Mr. Imtiaz Ali resulted in a 97.8 acceptance rate for Massey, GSK, Aventa, and Bryden, compared to a 66.9% acceptance rate for other companies? Are you aware of that?
I haven't seen that report, Chair.
Chair.
Do you know what function Mr. Ali performed at the DAC?
Mr. Ali was a screening officer, which means that...
What exactly is a screening officer?
So what Mr. Ali would have done to support the work of the Secretariat and the Secretary is that when applications are submitted or persons bring applications for registration, Mr. Ali would look at the documents being submitted for registration and cross-reference it against the requirements under the Food and Drug Act.
Right.
And that's his role and function, so it doesn't go beyond that.
So it's merely technical?
Yes, Chair.
Yeah.
I have a question. Yeah, sure. In the interest of the public.
Yes.
It's a public hearing.
Yes.
And we have put some people over the coals here. Rightfully so. Why aren't we allowed to name the names that the gentleman focused on of those 900 companies, those 900 drugs? Why? I don't understand.
I'm not saying we're not allowed, but we can. And let's address the elephant in the room.
Exactly.
The one company that this benefited the most is Aventa, isn't it true? Smith Robertson morphed into Aventa.
They've had most of the registrations.
Not most of. Mr. Ali, listen, I want to be very respectful to you, right? So let's, you know, we have a Trini saying, in Trini parlance, let me not try to play smart with stupidness, right? We know the company you're referring to is Aventa.
Over 100 million US dollars?
Yes, Mr.
Based on
and that is why I asked you earlier whether it was habitual for customs to determine who registered the product when shipments were being stopped at the port. Because the anecdotal evidence that I know of as a practicing lawyer, Minister Maraj knows of as a practicing lawyer, is that it is habitually done because they are the entity that registered the pharmaceutical. And that the marketplace is being unduly constricted by administrative arrangements designed to suit one company. That's my grouse with this whole thing, quite frankly.
Chair.
Mr. Naked, go right ahead.
Okay, so we now focus on that company. What our interest as people of this committee, members of this committee, 8 years passed. Could this have gone beyond the oversight of the minister, the then minister? Let's be clear. 8 years passed, this was happening. One company was benefiting. Is it possible? How is it possible that the minister didn't pick this up? Is that possible? In your experience, Mr. Ali, Mr. Ali.
So, Chair, through you, so drugs that are approved for registration would be approved by the minister based on the advice of the DAC. So all drugs that are approved or registered will be signed off by the minister.
No. I'm speaking about what the chairman unearthed here. about that change in regulation benefiting a company in particular to the tune of $100 million US. It's a public hearing, the public would want to know. How could this have gone on for 8 years without the minister, the then Minister of Health, not knowing this was happening?
I don't remember. I'm unable to answer that question.
All right, let's go a little deeper. Let's take it from another angle. The Dolphin app. That is an online system designed to sell pharmaceuticals to the general public. You agree with me?
Yes, sir.
And to cut a long story short, as we say in Trinidad, let's cut to the chase, as they say other places. The Chemistry, Food and Drug found that that app was in breach of the Food and Drugs Act.
Yes, sir.
Who owns that app?
Agostini and Company.
Part of the Aventa Group, isn't it?
Yes, sir.
When did the Chemistry, Food and Drugs first come to the conclusion that that app was in breach of the law? And I want to make it very clear just now, right? Not simply a breach of civil law, they breached the criminal law of Trinidad and Tobago. It's an offense under the Food and Drugs Act. Wouldn't you agree with me?
Yes, sir, it was a breach of the law.
Okay. But yet the ministry took 2 years to refer this matter to the police. Yes, 2 years. I have the evidence here. It's in your own submission. So familiarize yourself with your submission. It's there. You took 2 years to refer it. And perhaps Mrs. Tagley can answer that question. Is the offense under the Food and Drugs Act a summary offense? The answer to that is yes or no. Is it a summary offense under the Summary Offences Act?
Chair, I'd have to check that. Just allow me 1 minute.
Can you check quickly for me whether the use of the Dolphin app in contravention of the Food and Drugs Act Can you check to see? Sorry?
Yes, Chair. So the advertisement to the general public for human use of a third scheduled drug or controlled drug is an offense under the Food and Drugs Regulations, Regulation 48, and Regulation 51 confirms that a breach of that section, the person will be liable on summary conviction to a penalty of $300,000 or imprisonment.
Right. Are you aware that a summary offense carries a limitation of 6 months?
Yes. Well,
so why take 2 years to report it? If the ministry was of the view that it was a breach of the law, why wait until outside the limitation to report it? You can't charge them now. Let's be frank about that. So the reporting was what? Simply a cover to say we reported it, knowing fully well that we couldn't prosecute them?
so, Chairman, if I may, my understanding of the matter is that the offense continues and or continued up to a certain point.
It's a continuing offense.
And under
okay.
the...
Great. Perfect answer. Perfect answer. The police have refused to act. You agree with me? They have failed and or neglected and or refused to act. You agree with me? Well, let's put it this way. There's been gross police inaction thus far on this breach of the law. You agree with me, right? All right. you seem unwilling to answer the question. A report was made. From the date of the report, despite you saying it's a continuing offense, okay, no action has been taken thus far. All right. Don't shake your, sorry, Mrs. Dagley, you need to respond for the record.
Yes, Chairman.
Under the Food and Drugs Act, any food and drugs inspector can lay a charge. Does not need the involvement of the police. Any food and drug inspector pursuant to this act has the jurisdiction to lay a charge. There's no need for the involvement of the police. What has prevented the ministry for so long, in the face of finding of prima facie illegal conduct by a company, from instructing a food and drug inspector to go down to the magistrate's court and lay a charge? What has prevented that?
Chairman, if I may, the established practice in the ministry has been that once there's a breach of the legislation, the established practice, whether a referral is made to the DPP, following engagements with the TTPS on or around January, February of 2023, where we collaborated on some enforcement exercises in relation to breaches of the Act. The Ministry of Health was advised that we should send our reports where there have been breaches following the inspections directly to the TTPS, the Commissioner of Police. So following that discussion, all submissions will have been sent to the Commissioner of Police, with the exception of matters where we note that the 1 year, because we are cognizant of the 1 year, under our legislation is 1 year for the summary offense. We are cognizant of if the matter, we feel that there's been no action by the TTPS, we started copying the DPP in our submissions, bearing in mind
But hang on, you just told me it was a continuing offense.
Yes, so this is in specific relation to the Aventa app, but I'm speaking in general in terms of the practice of the ministry and the protocol, which is that you send the submissions to the DPP and or which on or around January, February of 2023, we're sending it to the TTPS because there was a joint exercise with the TTPS in terms of enforcement.
We're getting to that one. Operation Windsor, we're getting to that just now. We're getting to that just now. So, how many times have you all followed up with the TTPS about its inaction?
So we send reminders, Chairman, from time to time.
All right, can we get copies of those reminders, or would you exercise? I can very well understand if you want to exercise your power of privilege on that, okay? I could very well understand it. If Senator John Bates.
In relation to this whole, specifically to this whole issue of finding that the Dolphin Act was, as far as you understand, an illegal act, and you sent it to the police. When did you send it to the police, the report?
I would want to double check the dates when it was first submitted. The last reminder would have been sent around December of last year.
Okay, well, you could, when you first submitted it, I'd appreciate the answer.
Sure.
So, you averted a short while ago.
Okay, Chair, yes.
You agree with me?
I was not part of the team at that time, Chair, so I would have to agree.
I accept that.
Yeah,
Though
sure,
you were
sure,
not there, but
sure.
subsequent to assuming the role as the director, and perhaps this might be more aptly directed to Mrs. Siboo, is it?
Yes, Chair. Yes, Chair, it was a part of it.
How many super farm outlets were raided?
Chair, at the point in time, 0.
Zero.
On that day.
How many massive pharmacies were raided?
Chair, at the point in time, it was 0.
Where were the concentration of pharmacies which were raided? I know the answer, Mrs. Siboo. I'm asking you a question to which I know the answer. They're all in South Trinidad. Most of them were in rural Trinidad and Tobago. Am I not correct?
So you are correct, Chair. There was
Right.
one in...
And pharmaceuticals were seized and retained by the CFDD. Am I not correct that in Operation Windsor, very polite and discreet inquiries were made after complaints were made? Very polite and discreet inquiries were made at Superfarm and other pharmacies, and they were simply asked to take some products off the shelf?
Chair, I'm not aware of that.
You're not aware of that. Let's get to the auditing exercise. Right? As the chief pharmacist, you sometimes engage in routine auditing exercises. Am I not correct?
Yes, Chair.
Where you routinely audit importers and people who have warehouses and so on. Am I not correct?
Yes, Chair.
How many times have you audited Ultra Farm, the importer of Jameson and vitamins and other generic Apple line from Canada?
As far as I remember, it was once.
How many times have you audited Smith Robertson, Aventa, Bryden Pie, all of them?
Smith Rob was twice, myself, and then I do have other inspectors who would go in from time to time.
What would prompt an audit?
Basically, my unit would do antibiotics and narcotics. We usually have sight of the sales report. Upon looking or reviewing those sales reports on a monthly basis, if there's anything alarming coming to our attention, we would go in just to ensure what is happening there, in addition to products that may have come in without the necessary registration documents or the necessary import documents, which are permits for antibiotics and narcotics. We would usually go in.
Hang on a second. I'm somewhat at a loss here. If the customs operates efficiently, how do these unregistered drugs get into the country?
So from time to time, yes, they operate very efficiently because we do give them, but based on what we see on the sales report, we just go in to do a check to ensure that what is actually imported in is exactly what is supposed to be imported in.
When you say what is imported is what's supposed to be, what you mean? There's a discrepancy that exists somewhere along the line?
So it's just a matter of going in to double check to ensure what actually supposed to come in, Chair, is what really comes in, because from time to time we would find things going into pharmacies to do inspections. There may be some instances where you may find or information coming to our attention, an item, an antibiotic that may not be registered, so we go in to ensure. And it's just as a result of what would have happened historically, so that in order to prevent or ensure that everything is in compliance, we do it routinely or on an ad hoc basis in some instances.
Okay. Mr. Ali, I want to get back to you because I must confess, I'm not entirely satisfied with this explanation that Dr. Patron is a rogue public servant. Okay? I'm not entirely satisfied with that because ministries don't function that way. When an application is made for new drug importation, okay?
Yes, sir.
There is an evaluation process conducted.
Yes, sir.
right? It's called a dossier evaluation process.
Yes, Chair.
Isn't it true that there has been a level of pervasiveness, that these dossier evaluations have been conducted by drug registration officers and the secretary to the DAC, the same Dr. Patron?
Yes, Chair.
Wouldn't you agree with me that that is counterintuitive to the role of the DAC?
Yes, Chair.
And that evaluative exercise really should not be performed by administrative staff?
Yes, Chair, I agree.
Wouldn't you agree with me that that leads to a lack of objectivity in the approval process?
Yes, Chair.
And it removes the transparent nature of the approval process?
Yes, it does, Chair.
I want to get on to something else now. Huh? Yeah, yes, Minister.
I just, for clarity, I've heard about the Dr. Patron. Mr. Rowe, Dr. Patron. Is he the subject of any disciplinary procedure, any disciplinary action being considered pursuant to him acting as a rogue, ultra-virus the law?
No. No.
So hang on. P.S. Ali, I'm going to direct this to you. Well, I'll let Mr. Maharaj.
Mr. Chair, just by way of suggestion, before we continue calling anyone rogue,
yes,
maybe he should be present himself here before and not take one side of the story.
No, obviously, and that is why I put both Mr. Ali on notice that having regard to the very serious allegations which both of you have advanced against Dr. Patron, this committee intends to write Dr. Patron, inform him of it, and let him come and tell his side of the story. And from then we will distill the truth.
And maybe until then we do not use it to
rogue. All right. So we will.
Only that's the term they use. Just for the
I think I have to take culpability for that. I coined the phrase rogue public servant.
So just
I coined the phrase rogue public servant. But we will move on.
Or the alternate partem, all parties to be heard before you come to any conclusion.
It is every intention of this committee to invite Dr. Patron and Mr. Faz Khan and Mr. Imtiaz Ali on the next occasion where this committee meets to give evidence.
But, so Chair, just for the record though, just to be clear, Dr. Patron is not the subject of any investigation or disciplinary procedure at this point in time.
Not at this time.
Right. So that is a good segue into what I wanted to ask P.S. Ali.
Chair, if I may, there may be some processes that are underway in relation to the individual.
This is a good segue into what I wanted to ask P.S. Ali.
Mala, Ms. Tagli,
Yes.
I missed the first part, what you said as well?
There may be some processes that have commenced.
So should we be commenting on that here now?
In my respectful view.
Yes.
No, we will move on. So that's all I'm going to I will move on from that. All I'm going to ask P.S. Ali is that if you were of the view that the additions to this form were plainly ultra vires, did you commence any formal process within the ministry? I'm not saying disciplinary. Any formal process within the ministry to get to the bottom of how the law was subverted?
Yeah, not beyond what Mr. Ali would have done as part of his investigation.
All right. So, in effect, what both of you are telling me, all the members of the Ministry are telling me, is that there exists no documentary evidence evidencing any form of inquiry undertaken post-May of 2025. There's no document, no statements exist, no inquiry, no instructions to formation of a committee, nothing, no documents. All of this is done by word of mouth. That's the gist of what I'm getting here. All of this is done by word of mouth.
So, Chair, I would have written. So there are documents that would have been produced based on the investigation that was conducted. And I would have also contacted the members of the Drug Advisory Committee, informing them of the issues associated with the additions to the registration form, which I asked them to remove. And
right. Can we have copies of those,
sure.
All the correspondence,
sure,
which
Chair.
touch and concern the addition to this form, which we all agree was plainly illegal and plainly ultra vires, the act?
Sure, Chair.
I want to get on to another thing now that I was talking about supply chain management. And it is an alarming situation. On the first hearing of this committee, we got evidence that I think it was 70 million in expired or 80 million in expired drugs had to be destroyed over a period of time. P.S. Ali, would you agree with me that this is an unacceptable situation that has developed?
Yes, sure.
And that the national supply chain management for pharmaceutical is at a stage where it is unacceptably poor.
Yes, sure, it needs improvement, definitely.
I'm not asking whether it needs improvement. I'm asking whether it is unacceptably poor. Whether you accept that proposition.
Yes, sure.
And would you agree with me that this is so because the architecture is a fragmented one? You agree with me?
If by architecture you're talking about the different players in the system, where you have NIBDEC, the Ministry, and the RHAs, it may be more one of a cohesive information system, Chair, but it is fragmented.
Right. So that fragmentation results in financial obligations being created in advance of really approvals because it becomes so critical. You agree with me? Because the needs are not monitored to such an extent that there's predictability and the procurement is not undertaken in advance, it leads to a situation where you constantly have to rely on emergency procurement. You agree with me?
Chair, I wouldn't agree with that 100% because procurement is done in advance through NIBDEC. There may be different reasons for emergency purchases. Some of those might be the demand may have been more than we forecasted in terms of within the system. The other one may be the absence of supply from the global supply chain. So there has been emergency purchases, ad hoc purchases, but I'm not sure to be because there's not advanced procurement.
Ms. Khan, can I jump to you? Just briefly, P.S. Ali, if you could indulge me. In your request, in your submission, you have told this committee something which I think I'm sure the alarm, all my friends who sit on this committee with me would share the alarm, the alarm bells which you have sounded here. And this is what you say at page 18 of your submission. 100% of reported contracts awarded through NIPDEC for pharmaceuticals utilize the request for quotations to tender for these awards. Then you go on to say, the use of RFQ therefore signals a market that may not be very structured, that may be very structured or monopolized, and where procurement risks are significantly low. Is that the evidence that you have found of your review of the operations of NIPDEC and the acquisition of pharmaceuticals?
Yes, Chair. And that is based on the information that has been submitted to the OPR.
When we get to the OPR, I will tease out some more of that, because I have read your as you can see, I have read your submission with a great degree of alarm, and that's why I want to go on the supply chain management issue with P.S. Ali, and why it is that, one, drugs are allowed to expire because of a fragmented sourcing system where everything comes from different directions, and essentially the right hand doesn't know what the left hand is doing. Would that adequately describe what happens sometimes in the pharmaceutical industry within the state supply sector?
Sometimes, yes, Chair.
Would you agree with me that because of that untenable situation, that financial obligations are created when commitments have already been formed? Because of how the constant need to supply drugs on an urgent basis. Because it affects people clinically. It affects the delivery of very critical drugs to people who need them the most. And the emergency nature of it creates an untenable environment. Wouldn't you agree with me?
Chair, again, we're talking about the emergency nature, and as I said, there are instances where there are emergency purchases, but it is not that there isn't advanced procurement. If I maybe would just explain very, very briefly the process. NIPDEC goes out to tender, open tender, based on the needs of the Ministry of Health. We would identify what drugs we require in what quantities. They go to tender, evaluations are done based on bids that come in, and contracts are awarded. Those contracts are drawn down on during the contract period, the contract award period. There may be instances where the supplier cannot supply for different reasons. Where that happens, and if the drug is required because the stock we have on hand is not going to be sufficient to last us based on our consumption, that's when we go out to the open market, the emergency purchase as you term it. So that does occur, but I don't think it's...
Why is he talking about tenders? Can I just ask you to stick up in there? Ms. Khan, has NIPDEC ever published its tenders in the last 10 years? Its awards?
Yes, they have been.
They have been publishing?
Yes, they have been. Whether they are doing all, I cannot say at this time. Because the information that we get is so, much of the data we get is really poor.
No, I'm not asking you whether they publish their tender calls, you know. I'm asking you whether they publish their tender awards.
They are required to under the law, yes.
But have they been doing it in the last 10 years?
Well, I can't say, I could say from 2023, they have been doing some of it, but I'm unable to say if they've been doing all of it, Chair.
We'll get to that when we get to you, but Minister Maraj has some questions.
Mrs. Khan, I think the chairman is directing your attention to whether they publish the awards as regard to pharmaceuticals. We know NIPDEC is in a wide variety of business. So I think he was specifically dealing with pharmaceuticals. Do you have the answer to that question?
No, I don't. They are required to publish it. The OPR recently introduced Procure TT, which will give us better information on whether public bodies are indeed, based on their planned schedule of procurements, undertaking the tender and then publishing the award. But at this point in time, we would have to check, each and every website or in the newspaper to check to see if they are in fact doing so.
So your answer would be you don't have that information
I do not have that
hand?
information at hand, no.
So let's ask Mr. Ramphele. Mr. Ramphele, does NIPDEC publish its awards for pharmaceuticals?
It publishes the results online and they send a report to the OPR.
Okay. So if we were to check for the last 10 years, we would find every year you have published your awards for pharmaceuticals.
A 2-year cycle, and 2023 to 25, that's a 2-year cycle. It would have been published, as well as the, we'll be in a new tender cycle right now, so once the...
All right, so if we go back to every tender cycle, which we will when we break, we'll ask you to send information. We'll ask you to send the publications.
Sure.
How do you publish it?
It's on the website, and a report is sent to the OPR.
I want to ask you something before we break for the day, but I will get back to P.S. Ali, and then I will come back to you about something because of emergency procurement. P.S. Ali, do you agree with me that shortfalls in supplies to RHAs and so on are not episodic, but happens all the time?
It happens more frequently than we would like, Chair.
And it creates an environment where the RHAs have to go out themselves to procure medical supplies and pharmaceuticals on an emergency basis. You agree with me?
If these supplies are not available in the public sector, yes.
Right.
So there will be instances where you are destroying expired drugs because you have too much. And on the other hand, there are instances, many instances of emergency purchasing because it was short.
Unfortunately, yes, member.
So I think this adds to the chairman comment that there's a supply chain, was it to me?
There's a dissonance, a supply chain choke point.
Supply chain choke point. You agree with that?
Is a supply chain issue, yes.
But we're quite apart from that, and we're getting close to, I appreciate we've been sitting for a while now, and I want to, there's something that's troubling me because it's in the public domain, and it has to do with CDAP. Now, CDAP was intended, CDAP and pharmaceuticals and how it's paid for, because it seems to me the anecdotal evidence which comes to us in various forms suggests that pharmacies who are part, and this will go to, is it Mr. Ramphele? You are part of that as well, right? You administer that.
Yes.
So the pharmacies and smaller pharmacies and drugs and pharmaceutical suppliers which form part of CDAP or general NIPDEC supply, they're all paid by NIPDEC. Am I correct?
Yes.
Would you agree with me, and this is anecdotal evidence, as I said, that many of the small players, their debts are left to languish, whilst others receive preferential payment timeframes?
That's a question to Mr. Cozier. He's our finance and accountant. He might be.
No, but you are the general manager. I'm not going to allow you to pass that so easily. You are the general manager. You have general oversight over this. I would prefer an answer from you first.
So I know payments are made in terms of all CDAP pharmacies in accordance to payments that we receive.
So then why are CDAP pharmacies crying out sometimes in public that they haven't been paid for quite a long time?
It depends on when we get the releases to make the payments.
Depends on when you get the releases. All right. When Smith Robertson or Aventa sends their invoices to NIPDEC, what is the longest unpaid period that they have? I'll tell you, this is the anecdotal evidence that I have, right? Information that I have, and I want to know.
It varies between, it could be 60 or 90 days.
So one large drug pharmaceutical purveyor is paid within 60 to 90 days, but the smaller pharmacies are left to languish over 180 days, sometimes longer. Is my anecdotal evidence correct or incorrect?
It happens, yes.
It happens. Where do the instructions come from the payment? To NIPDEC, when you were there in your experience?
Generally, invoices, APs are submitted to the Ministry of Health based on requests that we receive.
Right, and when it's submitted to the Ministry of Health?
So the Ministry of Health would provide payments based on those outstanding invoices to us. However, there was a period in, I just want to get the period in, so it will be paid based on outstanding invoices. But there were part payments that were made for a period in 2023, I'm not sure exactly, I think March or April of 2023, which partial payments were made to various suppliers that were identified as being critical up to
Hang on a second.
23 to, so, go ahead.
Critical suppliers. Critical in what sense?
In terms of the type of pharmaceutical items that they were providing.
Okay. So those critical suppliers would have taken precedence over the ordinary pharmacies which service the rural areas of this country?
So we're talking suppliers for pharmaceutical items, like the big supplier, yes.
Well, you know, Mr. Ramphali, the big supplier, Senator Naked will tell you who the big supplier is, and I'll invite him to do so.
Aventa, 100 million US.
Yeah.
Aventa, 100 million US.
Isn't it correct, Mr. Ramphali, that you were instructed to give Aventa preferential payment over and above everybody else? Isn't it correct?
So, Chairman, there was a meeting that was held with NIPDEC and the Ministry of Health team from 2023 to a period early in 2025 that in terms of the various allocations of payments were dictated by the ministry.
All right, that's an interesting turn of phrase. Can we get that repeated, please? What did you just say? Repeat it for me.
In terms of the payments that were made, the various
payment allocations, the priority payment allocations were dictated by the Ministry of Health.
Yes.
And who from the Ministry of Health was there?
Representative of NIPDEC and executive team at the Ministry of Health.
Who from the Ministry of Health? Was the minister there?
Yes.
And the minister dictated the preferential terms of payment. The answer is yes or no?
Yes.
Sorry. Just, what what year we're talking about, or what
So that's
time
a period from 2023 up to 2025.
And for the edification of the public, who was the Minister of Health?
Minister of Health, Mr. Diyal Singh.
Terence Diyal Singh.
Yes.
The information is maybe Chairman, we could take the break now.
Well, I think we've reached at a critical juncture because this information we've gotten some alarming. I think we've reached at a critical juncture now where we've gotten some alarming information. One, we're hearing allegations about, and I'm going to resist using the term that we had previously coined. Well, I am hearing remonstrations from Senator John Bates, which I think needs further investigation. And now we hear that the general manager of NIPDEC is telling us that he was instructed by the previous Minister of Health to make preferential treatment to one big player. And Senator Naked has drawn the information out very clearly. I think we've reached a critical juncture now where, in order to further pursue this line of inquiry, the Secretariat will have to send out some further letters inviting people to come. We intend, having regard to the nature of the evidence emerging from the general manager of NIPDEC, I think all my friends will agree that we will have to write to the previous minister inviting him to come and clarify this evidence. Am I in agreement? Is everyone in agreement with me? So I think at this point, we had intended to sit until 4, but I think at this stage we will take the break for fairness, for procedural fairness sake. Before we go on, we will invite and provide them with the evidence provided thus far and invite them. So at this point, thank you all very much.
Chairman, I just have one question.
Senator
because the public will ask, is the former Minister of Health under any obligation to appear before us?
I don't think there is a legal obligation to do so, but we intend to write and invite. Yeah. We intend to abide, the standing orders does provide for it, but we intend to abide by the standing orders. So at this point, we will adjourn for today. I think this has been a very fruitful session, and we intend to continue along this line. So thank you all very much. We now stand adjourned to a date to be fixed, gentlemen and lady. Yeah. I think, no, before we go, we want to fix the date of hearing as Monday, March 9th, so that everyone knows. I don't intend to pursue this for quite a long period. I want to finish this inquiry because there are other inquiries we want to do. Afternoon.
Chairman,
yes.
at Monday, March 9th, should we expect to see those people you mentioned?
Well,
here?
we will write. Hopefully they will come. Thank you all very much.